Hi, my name is Joe Bartolomeo. I'm an Oregon Social Security disability lawyer. I have offices in Astoria and in Hillsborough. I represent claimants seeking disability before the Social Security Administration. And in this video, I'm going to give you some ideas about what to expect at your Social Security disability hearing. A lot of this is what I talk about with my clients before a hearing. Now, what I do when I'm working with a client is, before the hearing, we have at least a couple of pre-hearing appointments. In the first pre-hearing appointment, what I'm talking about to my client is what happens at the hearing, what kind of questions are going to be asked. I also tell my client about who will be present at the hearing. If I have some experience with the administrative law judge that's been assigned to the hearing, then I'm going to share that with my client. So a lot of what I'm talking about today is what I tell my clients in my initial pre-hearing appointment. When we get closer to the hearing, my client and I will then meet and we will plan and discuss what kind of testimony they should expect to give at the hearing. And we prepare basically a checklist or an outline of testimony so that we make sure everything we need to tell the judge has been covered at the hearing. But let's just talk about kind of what happens at the hearing. Now, if you look at the hearing in a very general way, every hearing is pretty much the same. Basically, what happens during the roughly 1 hour hearing is the claimant testifies about their condition and how it affects them. After they're finished, the vocational expert testifies, and they are there to give answers to questions about past work and what certain people with certain abilities can and cannot do. And then the hearing's over. Now, sometimes there will be a medical expert at the hearing. They testify about our client's medical issue and how it limits them. Sometimes a family member or a friend or a former coworker will testify at the hearing, and they'll talk about what they observe in our client or the claimant in terms of their limitations or struggles. And that's pretty much the hearing. Now, where we start to get a little bit more specific is when we talk about the specific judge that has been assigned to the hearing. Most of the judges, probably all of the judges in the Portland, Oregon Office of Hearings Operations, that's the Social Security Hearings Office where I do most of my work, pretty much all those judges are going to initiate the questioning. And then after they are finished, I get to ask my client questions that I feel are necessary. Some judges will only ask a few introductory questions and then turn it over to me pretty soon after the hearing starts. Other judges will go through a long list of questions and then turn it over for me to follow up with any questions that I may have. So it really varies, but I think the common thing is you're going to be talking with the judge initially. Now, let's talk about how you can get through your testimony, and I'll kind of share with you some of the things I tell my clients when they're getting ready for testifying at their hearing. So really what I'm doing here is giving you a few tips. And if you have a lawyer who's representing you on your claim and you're looking at this video, you really need to really defer to your lawyer. They're going to know more about your case than I do, but these are very general tips that I think most lawyers would probably agree with. Above all else, keep in mind that you're under oath and you have sworn to tell the truth, and if you don't, it's probably fatal to your hearing. I don't really spend a lot of time with my clients on this issue. I just make it really clear to them that they have to be honest and upfront. And actually, after having done this for 3 decades, I can say, and it's always refreshing for me to say this, most people are honest. Most people are doing the best they can when they testify at these hearings. Where I really see people make mistakes is where they decide that they need to give some kind of an answer. They're under pressure, they're nervous, and for whatever reason, they have concluded that if they say, "I don't know," or "I don't remember," they're going to be penalized. So what they do is they just throw out an answer, and it's just a random guess. Well, the problem with that is if you guess and you guess wrong, the judge might think that you're intentionally trying to mislead the judge with your testimony and may find that you're not credible. And there are thousands of rules, literally, and cases and policies that help judges figure out how these cases get decided. But really, at the end of the day, when you boil it all away, it's about your credibility. So the last thing that you want to do is guess an answer. If you don't know, then the right answer is, I don't know. If you don't remember, the right answer is, I don't remember. If you're not sure, make sure you tell the judge you're not sure. Like, I'm not sure, but, as far as I remember, but, I can't swear to it even though you've been sworn in, but, or give an estimate. That way the judge knows that you're doing your best, but you're not 100% on your answer. Here's another thing to keep in mind, and this might help you or put you at ease, and that is the subject matter of the testimony you give is, what is it like for you to be you? And nobody knows better than you what that's like, so you should be fine. So you'll be fine. And most of the judges are great. They will be courteous and polite and professional, so don't worry about that. There are a few that are more firm than others, but usually you're going to get a judge that is professional. All right, so let's move on to the other part of the hearing. So the vocational expert is an independent contractor that Social Security hires to provide testimony. The main thing to keep in mind is that they're neutral. They don't work for Social Security. They do not have any skin in the game. They're going to get paid no matter what happens on your case. The other thing to keep in mind is that the way the judge questions them keeps them neutral. They're not put on the hot seat. They're not going to get a question like, do you think that this claimant is disabled? Do you think this claimant could do any kind of work? And instead, they're going to be asked some basic questions, and then after that, they're going to be asked hypothetical questions. Now, without getting into too much detail, the first part of their testimony is, what kind of work did the claimant do? Remember, you're the claimant. What kind of work did the claimant do in the 15 years before they claimed their disability began? That's called the past relevant work. And what the judge is interested in is the skill level that you worked at and the physical requirements of your past work. And that's usually not an issue. Then what the judge does is they look at the file and they develop different scenarios of where they think you may be in terms of what you can and cannot do. And then they create hypothetical questions. And they'll say something like, assume you have a person the same age as the claimant with the same work experience and the same educational background. And then further assume that this claimant has these limitations. And then they're going to rattle off a list of limitations. And what they're doing is they're pulling different examples out of the file where they may go with your claim. And there may be 4 or more hypotheticals that are run by the vocational expert, and the vocational expert will say whether that hypothetical person can do the jobs that you did, or if there are other jobs out there that you can do. And a lot of these questions will depend on how old you are or were when you claimed your disability began. Again, the vocational expert is really not going to say up or down whether you're disabled. They will not be asked that kind of a question. We get to ask our own hypotheticals as well based on what's in the file, based on what our client testified to at the hearing. So that's the vocational expert testimony. Let's move on to the medical expert. Sometimes, not very often, the judge might feel it's necessary to have a medical expert testify at your hearing. This expert is an independent contractor. They don't work for Social Security. They are hired to testify, usually by telephone. They could be from anywhere in the United States. And they review your records, they listen to your testimony sometimes, and the judge will ask them questions. Basically, what a medical expert is testifying about is whether you meet an impairment listing, and if you don't, what your limitations are in a work setting because of your conditions. Now, an impairment listing is a checklist in the rules that basically provides if you meet the checklist items, you're disabled. It's a bit more complicated than a checklist. But the judge will usually lead off by asking the medical expert if you meet an impairment listing, because if you do, and the judge accepts that opinion, they're going to find you disabled most of the time. If the medical expert doesn't feel that you meet an impairment listing, then the judge was going to ask them about what your residual functional abilities are. That's a fancy phrase for what can you physically and mentally still do in a work setting. Now, it's possible that the medical expert may find that you have limitations, and even though you don't meet that checklist, you still are so limited that you can't work on a regular basis. So it's not the end of the world if a medical expert finds that you don't meet an impairment listing. They may still give testimony that supports your claim. And although many judges will defer to the medical expert, I have seen judges reject the opinion based on what they find in other parts of your file. And this is only one opinion. There may be an opinion from your own doctor in the file that supports your claim. So it's not the end of the world if the medical expert does not find you meet an impairment listing or finds that you still have some work ability. Now, that leads me to one last point. Your testimony, the vocational expert testimony, and the medical expert testimony are only pieces of the puzzle. You have your claims file and exhibits as well. So that's basically what happens at a Social Security hearing. We're talking about maybe an hour at most. Sometimes they go longer than that. I hope this was helpful. If you have other questions, check out our website. You can contact us through the website. You can call us. We have a Social Security guide. You can download that. It's free. I hope this helps you. Again, thank you so much for watching. Take care.